Alpha Day, the Committee on Health, Land, Justice, and Culture is now called to order. Today's Wednesday, September 15th, 2021. The time is 2:04 p.m. Notices for this virtual public hearing were disseminated via email to all senators and all main media broadcasting outlets on Wednesday, September 8th, and on Monday, September 13th, 2021. The notice was also published in the Guam Daily Post on the same days. The Zoom meeting is hosted by the legislature's AV staff and my staff, and I thank them for their assistance. The host of this hearing will mute all Zoom participants until called upon by the chair. Individuals testifying shall first be recognized before speaking and begin by stating their name for record-keeping purposes. We have 3 items on our agenda today. They are Bills 142-36LS, Bill 143-36LS, and Bill 144-36LS. I'm hoping to take a slight break in between each bill so that they can be recorded separately on YouTube. And otherwise, we will hear all of these contiguously. Bill 142-36LS is introduced by Senator Frank Blas Jr. It's an act to amend Section 25.30 of Chapter 25, Title 9, Guam Code Annotated, relative to ensuring that the offense of 4th-degree criminal sexual conduct against a minor cannot be reduced from a felony of the 3rd degree to a misdemeanor. Bill number 143-36LS, introduced by Frank Blas Jr., is an act to amend Section 25.15 of Chapter 25, Title 9, Guam Code Annotated, and Section 25.20 of Chapter 25, Title 9, Guam Code Annotated, to include other circumstances by which an individual can be found guilty of 1st or 2nd degree criminal sexual conduct. The 3rd item on our agenda is Bill number 144-36LS, introduced by Senator Frank Blas Jr. It's an act to amend Section 55.15 of Chapter 55, Title 9, Guam Code Annotated, relative to the crime of hindering apprehension or prosecution. I'd like to acknowledge the presence of my colleagues and thank them for joining us today, beginning with the sponsor of these 3 bills, Senator Frank Blas Jr. Thank you, Senator. Senator Anthony Ada, Senator Terlaje, and Senator Joanne Brown. Thank you, senators, for joining us. We'll begin now with the first agenda item, which is Bill number 142-36, which will be introduced by the sponsor. And for the record, I just like to note that the committee requested feedback on this bill and sent invitations to the Office of the Attorney General, Guam Police Department, Public Defender Service Corporation, Guam Bar Association, Guam Coalition Against Sexual Assault and Family Violence, and the Ali Shelter, in addition to publishing the public notices. All right, Senator Blas, you have the floor.
Thank you, Madam Speaker, and thank you to all my colleagues that are here, all those who are participating in this hearing as well. Bill number 146, Act to amend subsection 2530 of Title 9 Guam Code Annotated, relative to ensuring that the offense of 4th degree criminal sexual conduct against a minor cannot be reduced from a degree to a misdemeanor. Madam Speaker, as stated, this bill is to amend that section so that it reads, it adds a new section, subsection 3 to this section that a person, first off, a person is guilty of criminal sexual conduct in the 4th degree if he or she engaged in sexual contact with another person, and if either of the following circumstances exists. And it's to add on item 3 to this, which is that states the victim is at least 14 years of age and under 18 years of age. So what this basically provides is that if the individual was to commit a sexual act offense against an individual who is, again, below or under the age of 18, that the offense cannot be reduced. First off, it's a 4th degree criminal sexual conduct. It cannot be reduced to a misdemeanor, and the only time it can be reduced to a misdemeanor is if the offender or if the victim was over 18 years of age, and the offender was a first-time offender, and that's the only time it can be reduced from a felony to a misdemeanor. With that, Madam Speaker, I know that there are individuals that would like to be able to testify, and I'll hold off on any further comment until my closing. Thank you very much.
Thank you very much, Senator Blas. I'd like to recognize at this time the Deputy Attorney General Stephanie Mendiola, and to introduce all the representatives from the Attorney General's office and to testify.
Cesar Masi, Madam Speaker, sponsoring Senator Blas, members of the committee and other senators. As Speaker mentioned, for the record, I am Deputy Attorney General Stephanie Mendiola, the General Counsel for the AG's office. Also representing our office today is Assistant Attorney General Christine Tenorio, who's a senior prosecutor in our prosecution division. We have testimony, or we're appearing today in support of Bill 142, and we have written testimony to indicate that we have a minor amendment that we would suggest to the bill. Hopefully you consider minor amendment we would suggest to the bill. And if you would like, I could read our testimony into the record. Speaker, your office should be receiving it by email soon.
Oh, yes. Well, please read it if you don't mind. Yeah.
Okay. One second, dispensa. Oh. Hafide Speaker Terlaje, thank you for the opportunity to provide this testimony in support of Bill number 142-36 COR. Over 100 criminal sexual conduct cases are referred to our office each year, some of which involve children as young as 4 years old, and most of which involve a parent, other relative, household member, or authoritative figure as the actor. We are supportive of legislative efforts aimed at curbing this horrendous behavior, including those proposed by this bill. Under current law, 4th degree CSC occurs when a person engages in sexual contact with another person and either force or coercion is used to accomplish the sexual contact, or the actor knows or has reason to know the victim is mentally defective, mentally incapacitated, or physically helpless. When read together with the related provisions defining 1st, 2nd, and 3rd degree CSC, in effect, 4th degree CSC involving minors is applicable when the victim is age 14, 15, 16, or 17, and the actor is a non-family or household member, or the victim is age 16 or 17, and the actor is a family or household member. However, because the definition of 4th degree CSC does not specify an age range, in contrast to 1st, 2nd, and 3rd degree CSC, age alone is not enough. To sustain a charge of 4th degree CSC against minors 16 years age, 16 years and older, the government must also establish either of the elements identified above, use of force or coercion, or knowledge of mental defect or incapacitation or physical helplessness. Although 4th degree CSC is classified as a 3rd degree felony, an exception exists when the actor is a first-time CSC offender, in which case it is reduced to a misdemeanor. To put it another way, a first-time offender who engages in unlawful sexual contact with a child 14 to 17 years of age faces a misdemeanor charge. A repeat offender faces a felony charge. And there's a footnote to indicate in comparison, a person who damages another person's car faces a felony charge. That said, we support the proposal of Bill 142 to specify an age range for 4th degree CSC. However, we recommend amending the proposal such that the standalone age range includes 14 and 15-year-olds. So it would read, subsection 3, the victim is at least 14 years of age and under 16 years of age. This approach affords both respect for and reconciliation with our age of consent law. To be clear, this does not eliminate the ability to prosecute 4th degree CSC where victims are 16 or 17. Those cases will continue to be charged under the existing framework. And lastly, we support the proposed amendments to subsection B to uphold felony charges where the victim of 4th degree CSC is a minor, and limiting the exception for misdemeanor reduction for first-time offenders only in cases where the victim is an adult. And we do not propose substantive changes. However, we do propose revised phrasing for consideration, and that would be subsection B, criminal sexual conduct in the 4th degree is a felony of the 3rd degree, except it is a misdemeanor where the actor is a first-time offender and the victim at the time of the offense is 18 years of age or older. Thank you again for this opportunity and for your consideration. We hope we may look forward to passage of this bill as another step forward in protecting our children, especially from this type of egregious harm. Sinceramente, Stephanie E. Mendiola, General Counsel, Deputy Attorney General.
Thank you, Deputy Attorney General. Attorney General Tenorio, would you like to testify as well?
Dag Mendiola covered most of the written testimony or the complete written testimony that we had gone over. I just wanted to elaborate and clarify that the proposed amendments would be congruent with the third-degree criminal sexual conduct statute as it is written. As it stands right now, misdemeanor criminal sexual conduct is the default in cases where we have the minors who are above the age of 16, because that is the age of consent. I do want to give a quick statistic just for the need for the bill, and then any other testimony I can respond to questions and to questions later. However, the currently as charged, the victims who comprise this subset that we're trying to change is 10% of our charged cases, meaning 10% of minors are only being, their offenders are only being charged with misdemeanors because of the way the law is written right now. So the Attorney General's office supports the amendment. Thank you.
Thank you very much. We'll now hear from Deputy Director of the Public Defender's Office, Mr. John Morrison. Attorney Morrison.
Thank you, Madam Speaker. Senators, my name is John Morrison. I'm the Deputy Director of the Public Defender. I wanted to first start by acknowledging who I'm speaking on behalf of throughout this testimony. I'm speaking on behalf of our internal management here at my office and our attorneys. I'm not speaking on behalf of our board, as they're a board set by statute. I haven't discuss the testimony with them, and they probably wouldn't be in a position to comment on these bills based on the positions they hold. So with that being said, my office is opposed to the legislation as drafted. I'm only going to comment as to the legislation, the proposed legislation that's before me, but it was as drafted and consistent with Guam law. Paragraph 3 reads that the victim is at least 14 years of age and under 18 years of age. Our age of consent on Guam is 16 years. So this law as written would effectively make it unlawful for someone to engage in sexual contact with someone who is 16 or 17, but still legal to have a relationship with someone of that age that involved sexual penetration. So that was inconsistent with Guam law as written. Now, I think some of my testimony is just based on personal experience in having these types of cases, and I can tell the committee here that in my view, it's relatively rare for the fourth degree to be charged out in the first instance. The way I read the act, it seems to be an effort to minimize plea bargaining on these types of cases. And I'm not sure that that's essentially fair to the people that touch these types of cases. It certainly hasn't been my experience that the Attorney General is going out of their way to cut pleas for fourth degree on every case that they get a hold of. That's just not accurate. I think these cases are prosecuted zealously. So I would take a certain amount of exception to seeking to limit them in their discretion. These cases are difficult, and I think we do get into situations sometimes where the best result that the Attorney General can get is a negotiated disposition, whether or not that means that the victim in the case doesn't remember what happened, although they made an initial report, or the family is adamant that they don't want the victim to take the stand and testify. I do think it is important to have a charge that can sometimes be negotiated. that still is going to trigger major consequences for the defendant. And for a sexual charge like this, even if it's a misdemeanor, it's going to trigger sexual registration requirements and periods of probation and the like. Senators, those are my comments. As written, my office is opposed to the bill. Thank you very much.
Thank you very much. Thank you very much. I now like to ask Senator Blas if he has any questions or comments for the panel.
Thank you, ma'am, very much, Madam Speaker. I guess my question is to Attorney Morrison with regard to you stated that your office was objected to the bill as written, but then you also made reference to the subsection 3, the new edition of it being up to age 18 years of age. According to the Attorney General's office, they are proffering and they would like to see an amendment so that it is consistent with law. First off, let's understand, okay, I'm a traditionalist, okay, and I'm conservative, and so as heavy on the law as it can be, I will be. However, if it is the and it appears to be the suggestion as well from your office that section now basically read that the victim is at least 14 years of age and under 16 years of age, then would your office still be opposed to the bill?
Senator, yes, I'd have a little less concern about it if that's the way it was drafted. However, I can tell you all that in my view, these charges usually do get charged out at a more serious level. Generally, there's a force or coercion element that is charged out, or the particular circumstance of the case allows the government to charge out one of the more serious charges. So I would be surprised to see this charged very frequently if it were entered into law. I think the charges that currently exist allow for a great deal of charging discretion and for the government to seek the right charge.
Okay. I guess to the Attorney Tenorio or Ms. Attorney Mendiola from the AG's office, your comment on that?
May I respond?
Sure.
Thank you, Senator Blas, Madam Speaker. So as the head of the sex crimes unit, I actually disagree with Mr. Morrison because I did pull the stats this morning and I've gone through every single pretrial criminal sexual conduct case that the Office of the Attorney General has. Mr. Morrison's comment is only accurate because he is referencing sexual penetration. The problem is that there's no corresponding felonious sexual contact charge. And while Mr. Morrison says that he thinks that it's going to be not used or charged less, I just gave the statistics where it's 10%. So 10% of all of our cases now would actually be converted from a misdemeanor charge to a felony charge. And to say, I just want to stress the importance of the bill. Out of the 10% of the cases that we have, most of those cases are biological fathers molesting their biological daughters, and it's a misdemeanor under Guam law. And so I don't think that it is accurate to say that this is not a common charge because I went through the statistics this morning. So that is my comment on that.
Thank you. Attorney Mendiola?
Thank you, Senator. Yeah, as a matter of practice, I of course would echo what Attorney Tenorio was explaining in terms of the statistics. But I think the issue is that it sets the amendments would set it up so that age would be sufficient for 4th degree criminal sexual conduct. Attorney Morrison is correct that There is already an existing avenue to prosecute for coercion. I hesitate to say that it would necessarily make it easier, but it's allows, I mean, in effect, that's what it does, because it makes it more clear that age alone is sufficient, and this 14 to 15 age range is the only age range under the age of consent that's currently not captured for sexual contact specifically.
Okay, Attorney Morrison, I'll be fair. I'll give you an opportunity to be able to respond.
Thank you, Senator Bluss. I would maintain my position here. I believe that the government has ample latitude to charge out these types of things. The Guam Supreme Court has been quite liberal in its definition of what force or coercion is. So I believe the majority of these cases are going to be charged out under that statute section. And I think it's important to remember, I mean, none of this conduct is good or advisable or something I'm advocating for, but the bill is specifically addressing sexual contact, which is the touching of the intimate parts of somebody, even over their clothing. So we're not dealing with some of the more significant types of contact that we're going to talk about in some of the other bills.
Okay. Well, as I stated earlier, okay, I'm a traditionalist. I'm also very conservative, so I appreciate your comments on this thing. So thank you, Madam Speaker.
Thank you, Senator Blas. Will now recognize Senator Ada.
Thank you, Madam Speaker. I don't have any questions for any of those who testified on the bill. Thank you.
All right, Senator Taitigui.
Thank you, Madam Speaker. And thank you to the Attorney General's office for being here to testify, as well as Attorney Morrison. Appreciate all your input into this. There are some things I'm not quite sure of, you know, not being an attorney, but listening to some of the language that you said, Attorney Morrison, you mentioned charged out. And you said that a couple times. Can you kind of explain to me what charged out means and give an example?
So, Senator, the job I had before being an attorney was like working in a stock room. So it's basically the only job I've ever had. It's been a long time. I'm pretty indoctrinated to the way we speak, and I apologize for that. I just mean that that's what the government charges when I say charged out. That's they screen the case, they make their decision, and that's what they file papers on.
I see. And I mean, you're still pretty, you know, what's the word? You know, standing your ground on not supporting this legislation. Oh, and before I forget, if you can please provide a written testimony, it's going to be very helpful so we can review that. I don't know if you provided one yet.
We have not done that yet. Could I just get direction on how long my office has? Because I know some of the other attorneys want to submit that. Is it 10 days from today or earlier?
I'll allow the speaker to answer that. How long do they
Yes,
have?
I apologize. I had not thought about that, but I guess we will allow 10 days. Yes. Thank you.
Okay, greatly appreciated. And maybe you can have the opportunity in depth to discuss why. I mean, something like this is not something that you don't support. And when you say minimum plea bargaining, can you kind of explain that scenario when you talked about minimum plea bargaining?
Perhaps I use that phrase. I was discussing just, I guess, the process where we decide if a case is going to go to a trial or is going to reach a negotiated plea agreement. So I know reasonable minds can differ on whether or not the Attorney General's office should be offering pleas in certain cases. But I can represent that they're zealous, particularly in these types of cases, and I don't perceive that they're giving anything away.
Oh, okay, thank you, Attorney Morrison. I appreciate those answers. And yeah, I guess definitely this might be a question for you. For the past 5-year period, how many CSC convictions have been eligible if Bill 142 was enacted? Would be eligible. Would have been in the last 5 years, sorry.
We wouldn't be able to tell you the last 5 years today. We can check the stats that we have for that. And Attorney Turner, please correct me if I'm wrong. Where we're at within 1 year of 113 active cases, 83 would have been eligible.
Oh, okay, within 1 year period of time. Okay. Just within this year.
Sorry,
Is that
Dagman,
Bill
it was
2020?
the other way around.
Okay.
So,
You can go ahead and answer the question. Okay.
Yeah. Thanks.
okay, you're welcome. So when we did the statistics, what it is 83 of the 113 criminal sexual conduct cases that we have currently active, meaning pretrial status, 83 involve minors, period. But 12 of those are only misdemeanors because of the way the law is written. If I may respond to the plea bargaining issue, just so maybe I can shed some light and it would help Senator Terlaje.
Yes, please.
So I knew that Mr. Morrison and I work together frequently, so we are no strangers to this set of crimes. With regard to plea bargaining, that's actually not what the proposed amendment to the statute wouldn't affect plea bargaining. The current state of the law is that as a prosecutor, I am not permitted to charge 4th-degree criminal sexual conduct as a felony for adults, including biological fathers or household members who molest their children who are 16 years of age or older. So what the current amendment would do is allow the prosecutors to charge it as a 3rd-degree felony as the outset, because we're not permitted to charge it that way. We're only permitted to charge a misdemeanor. So at the outset, if you read, and this is including our amendments that Dagman Diola had mentioned earlier, which would be, even if subsection 3 is amended to say under the age of 16, the whole statute would have this practical effect. 14 and 15-year-olds will always, if they're a victim of sexual conduct, their offenders will always be charged as a 3rd-degree felony at the outset. 16 and 17-year-olds would also be charged as a 3rd-degree felony, but only if we could meet subsection 1 and 2, meaning it was by force or coercion and your victim was 16 or 17, or your victim was physically helpless, mentally defective, or mentally incapacitated, and they were 16 and 17. Because the whole point of upgrading it to a felony is to protect the children because it is felonious conduct. So to the extent that it would affect plea bargaining, it actually really would affect the charging of it and what prosecutors would be permitted to do.
So it would basically, what this law would do is go straight to a 3rd-degree felony then, right? I mean, you even bypass the 4th degree, you just go straight to 3rd degree. So it allows you that ability, right, to prosecute under those I guess, 1st degree, 2nd degree, 3rd degree. So it basically does that, right?
So not necessarily. So 1st and 3rd degree criminal sexual conduct are for penetration. 2nd degree and 4th degree criminal sexual conduct are for misdemeanors. I think that where it gets confusing is that what we're trying to do is make 4th degree criminal sexual conduct a 3rd degree felony. So
right.
When we say, right, so it would, you're correct in that it would allow us to go straight to charging 4th degree criminal sexual conduct as a 3rd degree felony if it's a minor.
It's
The adults would still be chargeable as misdemeanors, or if the victim is an adult, and if the
Okay.
offender is a first-time
So
offender.
so that's 14 to 17, which is still considered a minor.
Correct.
So, and even though the law currently right now has, consent at, I believe it was 16 years, then it's those last 2 years that would still maintain, well, boom. Then you would have to kick out the current law.
So
Yeah.
with respect to that, Senator,
Yes.
that's why the qualification would be if it's amended with the proposed changes we have, 16 and 17-year-olds, even though there's an age of consent, the subsections force or coercion and physically helpless, those are non-consensual. So basically we would be proving an additional element to get to third-degree felony, which would be that it was non-consensual contact and your victim was 16 or 17. That's how we overcome consent, because it would be basically non-consensual contact with a 16 or 17-year-old.
Okay, thank you, Christine.
welcome.
It was very, that was very good. I was able to understand it and follow along with regards to that. So it sounds to me like it's not just only one amendment that Stephanie, sounds like you might need another amendment in there to make it clear, right? So I know that we have 10 days and maybe we can work on this legislation to, and basically to accommodate both sides, the public defender's office as well as yours as well, with any concern. My last question, Steph, it sounds like you or Christine, sounds like you studied this quite a bit. What other jurisdictions have this type of law?
Our jurisdiction is directly, our particular statute is directly correspondent with Michigan. So Guam's criminal sexual conduct laws are derived from both Michigan and Minnesota. So that's where this law comes from. But as far as the grade of offense, every state has this type of law, but all the states differ in what the grade of offense is. So I'm not sure what the stats are as far as who considers it a misdemeanor and who considers it a felony, but we're the state that's trying to make it a felony.
Okay, so you went through Michigan and Minnesota it's kind of mirroring this scenario. So California law, which California and usually Hawaii are two states that we kind of look to all the time. What's California's law regarding this? Do they have this particular law in place?
They have the law in place. I don't know about the offense, what they grade the offense as. So we can, Dag Mendiola and I can get that for you. It's just we focus on Michigan and Minnesota because when our criminal sexual conduct laws were drafted, it came directly from those two states.
I see. Oh, okay. So you've been working on this particular legislation. Okay. Thank you, Christine. It's always a pleasure to see you. You're doing great over there, Stephanie as well. And Attorney Morrison, I greatly appreciate all your comments that you made and looking forward to your testimony. Anything you want to include in that, this is the opportunity to do so. So I appreciate your time. Thank you, Madam Speaker.
Thank you, Senator.
Thank you, Senator Taitakwi. Senator Brown, you're recognized.
Thank you very much, Madam Speaker. I wanted to ask the AG's office, just in comparison for Guam, how do we rank percentage-wise with regards to these type of criminal sexual conducts against our minors in our community? How do we compare nationally? Either one from the AG's office.
Unless Dag Mendiola wants to start, I think I kind of have the answer to that question. So as far as charges per capita, we actually rank as one of the highest rates of sex offenders that are charged. That doesn't mean necessarily the highest rate of conviction, but it is the highest rate of, we have one of the higher rates of criminal sexual conduct.
And in comparison, I mean, because obviously it could happen also to an adult, but in terms of minors, is that also the same, that with regards to minors, Guam is also pretty much up there?
That is correct. And I also this is also based on anecdotal evidence because yearly I actually go to the National District Attorneys Association conference just for sex crimes. So I'm able to network with all the other sex crimes prosecutors. Criminal sexual conduct with perpetrators within the family is common everywhere. But I think that on Guam, we have some families just have greater access to children because of the nature of multiple family households. So that's why our rate is so high.
And with regards to when these cases, you said, you know, in terms of those that are charged, but what is the percentage of conviction when these cases are brought before the court?
So that's a more complicated question. I do know that there was a article that was run or an op-ed that was run, and those statistics are not necessarily accurate. And the reason why that's a complicated question is because before us today, we're only talking about 4th degree criminal sexual conduct, but we would actually have to go back and to answer the question, really understand what the question is, whether it's how many people are charged with 1st degree, 2nd degree, 3rd degree, 4th degree, or if the question is just how many people are charged in general. We actually can have we actually do, I think, have the statistics readily available. I just don't know them off the top of my head.
I think it would be good if you could provide that to us, certainly before this bill moves forward, it gets to the floor, so we can collectively have a good understanding of what is the success rate. And again, of course, I think it's very concerning, obviously, that this is a prominent problem in our community where we have these type of offenses happening. You know, imagine, I mean, especially within a family, a fellow trusted adult to a child, or, you know, a young person that's underage here. To have this happen, I mean, I think we all agree this is not acceptable behavior, but I think it would be very helpful to know what that is. And certainly understand the desire of the author of this bill to want to strengthen the process so that it's not handled as not as a non-serious offense, because obviously it's very offensive and very serious. But I think having that information would be very beneficial for us and the public as well. I mean, you know, we see these charges happening and we see every day these mugshots in the newspaper as if this is commonplace. And I just think it would be good to know specifically where do we have the biggest problem, because at the other end, we're going to want to know how are we targeting these issues and how are we being proactive in the community in getting this information out and getting this information out to young people as well, to know that this type of behavior is not acceptable, and for them also to have a vehicle and how they can report it. Because imagine if it's within your family, probably it's not something they would ever want to, most probably don't talk about. And these are the cases that you're aware of. What about all the ones in the community, certainly that never get to that level because it's kept within the family, or fear, you know, of revealing these issues outside of the family. So I think it'd be good to have that information available. With that, Madam Speaker, thank you very much for the opportunity to ask a question and comment with regards to Bill 142.
Thank you, Senator Brown. If I could ask a couple questions myself. Okay, first I'm trying to understand the intent, and that is, so we're saying that there are some cases right now for victims who are 16 and 17, if the crime is sexual contact and not sexual penetration, that we cannot charge as a felony. We can only charge as a misdemeanor, and that this bill would allow us to charge as a felony. Is that right? Or a 3rd degree felony. So increased penalties and everything like that. If that's the case, so right now, under this 4th degree, no crimes against children, or sorry, anyone below the age of 18 is charged under 4th degree criminal sexual conduct. Is that right? It's not one of the criteria. I mean, unless they meet these other criteria.
So, right, Madam Speaker, if I may. So as far as contact with minors, we currently can charge under minors under the age of 14 with 2nd degree criminal sexual conduct. And that is considered a 1st degree felony. But before the 14, 15, 16, 17-year-olds, they're by default all a misdemeanor. We're not permitted to charge it as a felony. So there's kind of a disparity there because it goes from second degree criminal sexual conduct as a first degree felony, and then it's fourth degree criminal sexual conduct as a misdemeanor. And so you skip second degree, third degree felony, and then it's just a misdemeanor.
If I may add, Speaker, just to add one clarification to Attorney Tenario's description for 14 and 15-year-olds. Well, the bill that's before us addresses sexual contact, and for 14 and 15-year-olds, they are also included in sexual contact under second degree CSC as a first degree felony, but there has to be more to the case. The bill before us, just sort of to connect it and repeat, the bill before us makes age alone enough. So the fact that they're 14 or 15 would be enough. Right now, under the law, maybe this is what Attorney Morrison was getting at earlier, there's 14 and 15-year-olds we are able to address, but it requires something more to be proven in that particular case.
All right.
And thank you for that correction, Dagmandiola. So she's correct, it's 14 and 15-year-old, but we also have to prove family or household member.
Okay. Now if we could just look at the language. So subsection 3, victims at least 14 and under the age of 18, or let's say under the age of 16. If we put 16, what happens to the 16 and 17-year-olds? I thought that was who you're going to affect here, but it looks to me like they would be left out. What would happen to the 16 and 17-year-old victims?
I could address that in terms of the recommended language to be proposed, and then Attorney Tenorio could jump in practice. What we're recommending as a revision to the language would remove 16 and 17-year-old from the pathway, so to speak, where we're prosecuting when age alone is enough. So for 14 and 15, age alone would be enough. For 16 and 17, we would have to prove something more. So they would 16 and 17-year-olds would fall under the first two provisions of that same section, which I think Attorney Morrison was getting at earlier. That addresses the age of consent, where 16 and 17-year-olds are able to give consent. So they wouldn't automatically, someone wouldn't automatically be charged as a felony if they engaged in sexual contact with a 16 or 17-year-old. There would have to be something more in that case for 16 and 17-year-olds. So we wanted to be clear, and the testimony was submitted, so it might be easier to see on paper, but we wanted to be clear that it doesn't mean that we still cannot prosecute in cases that might justify a second look for 16 and 17-year-old sexual contact, for sexual contact with 16 and 17-year-olds. But we would leave that sort of as is, so to speak. We wouldn't change the law for 16, 17-year-olds, just for the 14, 15-year-olds.
All right, so AG Tenorio, what about 16 and 17-year-olds who the perpetrator is a family, as you described, the biological fathers? How would they be charged?
So under the new proposed law, they actually, if the new proposed law says 14 years of age and under 16 years of age, but subsection B is kept because the AG's office didn't have any amendments to that, which says, however, if at the time of the offense, the victim is 18 years of age or older, 16 and 17-year-olds would still be chargeable as a third degree felony if you read it in conjunction with subsection 1 and 2.
Okay, got it. Thank you for walking me through that.
You are
Okay.
very welcome.
This is complex, and I always have to take a long time for these because of the degrees of conduct versus the degrees of felonies. Yeah, so thank you. We're going to probably allow as much time as is needed on these bills. And so definitely, Deputy Director, you will have 10 days. So please, if you need more time, let me know. Otherwise, and if either of you have any additional comments, I got your written testimony. Thank you very much. Then, yeah, but please let me know if there's anything else. And with that, I invite Senator Blas to close on the bill.
Thank you, Madam Speaker, and thank you for your testimony on this bill. Madam Speaker, if you permit me to, I have also a written testimony from the Guam Police Department that was sent to my office, and that if you can, I'd like to be able to read it into the record. It's fairly short.
Sure, yes, please do. And in fact, I'm afraid I have another question for the AG. Yeah, I forgot to ask. So please.
So you want to go ahead and ask the question, and then I can do the.
Yeah, if I could. So does anything, nothing by putting this language in this statute would inadvertently allow an argument to lower the degree of felony against offenders whose victims are outlined under the second degree criminal sexual conduct? I guess they don't have that argument, right? It's up to your discretion how you're going to charge it. Okay, but it's possible they would fit under both categories.
So Madam Super, to address that, the category that would overlap would be if your victim is a 14 to 16-year-old and a family or household member, that's chargeable as second degree, but those victims would still be included as a third degree felony here. But the way it's not actually a charging discretion, because second degree has the additional element of family or household member, that actually would be the default charge. And then when we charge it to the jury, the fourth degree criminal sexual conduct would be considered a lesser included offense. If they didn't find family or household member, they could just find age.
All right, thank you very much. Okay, Senator Blas.
Okay, thank you, Madam Chair, Speaker. So this is a letter from the Guam Police Department dated September 15, 2021. It says written testimony, re Bill 142-36. Dear Senator Blas, buenas and half a day. I am submitting this written testimony in regard to Bill 142-36, an act to amend subsection 25.30 of Chapter 25, Title 9 Guam Code annotated, relative to ensuring that the offense of fourth degree criminal sexual conduct against a minor cannot be reduced from a felony of the third degree to a misdemeanor. Criminal sexual conduct crimes are investigated by police as violent crimes alongside murder, robbery, and aggravated assault. In this category, criminal sexual conduct cases occur more often and unfortunately victimize more minors than any other crime. The GPD Domestic Abuse Response Team, or DART, is primarily responsible for investigating CSC cases reported to the police. DART provides that in the previous 3 years, the criminal sexual conduct cases reported to police reveal an extremely high number of minors being victimized. In 2018, 180 of the 266 CSC cases, or 68%, involved minors. In 2019, 169 of the 249 CSC cases, or 71%, involved minors. In 2020, 142 of the 190 CSC cases, or 75%, involved minors. Violent crimes committed against minors are serious incidents and at the least should maintain its status as a felony and not be reduced even for first-time offenders. Therefore, on behalf of the Guam Police Department, we are in support of this bill and respectfully request for the recommendation mentioned herein be considered and included in Bill 142-36. Respectfully submitted, Stephen C. Ignacio, Chief of Police. I wanted to be able to read that into the record, Madam Speaker. I'm sure my office will be forwarding this to the committee for inclusion into the committee record. With that, Madam Speaker, this bill actually has been stated and has been a concern by the Chief of Police. As a father, a grandfather, a great-grandfather, the last thing in the world I want to hear is that any one of my children, any one of my minor children, are victimized. And if we can, as a body, lawmaking body, provide statute so that as a deterrence, provide that, that look, don't even go there. Don't even go there with children, because then it's going to be a world of hurt. That our society, our community does not tolerate any criminal sexual misconduct against anybody, much more so if it is a minor. And what this bill would hope to do would help to strengthen those laws so that if an individual does want to take advantage and does take advantage of a minor, in these cases, that there is a severe penalty to be considered that they can that they can come up against. So with that, Madam Speaker, I am urging my colleagues here for their consideration in this, and I'm asking that the committee, we work with the committee to work with the proper amendments, the amendments that have been proffered, so that we get all the information so that can be brought before our body for consideration. Thank you very much.
Thank you, Senator. There being no further, is there anyone who'd like to say anything else before we conclude on this one bill? If not, this committee will consider this hearing adjourned for Bill 142-36. We will continue to accept testimonies for 10 days. And I ask that anyone who needs an extension to please let me know. Otherwise, you can submit testimony to my email at senator.terlaje@gmail.com. We're going to take a momentary break before Bill 143, just for audio to reset the audio. Thank you.